Good afternoon, this is Possession Friend from a very quiet county court. That's because of the 3-month suspension on possession, which all residential landlords will know, under Practice Direction 51Z. We've been prevented from having possession for 3 months, and also all existing cases have been stayed and our possession proceedings have stopped. Now that is until the end of June. But don't forget, we can still serve notices. We can still serve a Section 8 and a Section 21 notice, but they will need 3 months notice for both. Instead of 2 months for Section 21 and 14 days for Section 8, we can still serve the notices if we have to, but it's a 3-month period of notice. Now, also to tell you that the claim form for possession following Section 21, the Form N5B, was 7 pages long. It's now recently, since the beginning of April, been revised, and it's 18 pages long now. So have a look at that now before you need to use it to get possession, to familiarise yourself with what it's asking, what questions it's asking you. And if you've got the impression that courts didn't want you to get a tenant evicted, I can understand why. Look, there are still some limited options available for landlords, okay? So we've got some free advice, so do contact us if you have a problem, and we'll see what levers we can bring to bear for you that might help. Now, the Secretary of State, Robert Jennick, said on the 4th of May to the Parliamentary Select Committee that the period of possession suspension until the end of June could be extended. And he'll take that decision nearer the end of June, and I think realistically it's going to be extended by the way things are looking. He also, more worryingly, said that he's working with the Lord Chancellor and the Lord Chief Justice on a beefed up pre-action protocol. Now that pre-action protocol can be subject of another video, but just to suffice to describe it as a long and laborious means of getting possession for rent arrears. Now, on the slightly upside, there's a case of Arkin versus Marshall that was heard at the Court of Appeal on the 30th of April, and that decision is expected on Monday the 11th of May, and we will update you via Twitter on the result. And that appeal basically is against the legality of the suspension of possession. Justice delayed is justice denied, as they say. Now, if we look at residential possession being totally abandoned for 3 months and compare that with commercial possession, at the end of April, the government announced protection for commercial tenants under the Corporate Insolvency and Governance Bill 2020. Now, the two crucial differences for commercial tenants is that it does allow for forfeiture for arrears that are not COVID related, and also it has not stayed existing or pending cases. Now that's the position that the government should have taken with the residential sector, because what they've done is they have stopped 95% of lawfully compliant tenants moving into and securing accommodation, whilst protecting 5% of tenants who are responsible for antisocial behaviour, domestic violence, criminal damage and rent arrears that are not COVID related. So look, follow us on Facebook at Possession Friend, call us for free advice, take advantage of that, and in the meanwhile, stay safe and look after yourself.